Hello, welcome to our live virtual intellectual property practice area info and networking session. My name is Albert from Summer Associate Hub, and I'm proud to have you all here. As a former intellectual property or IP associate, I'm extra excited about this as I feel IP is the most underrated practice area. This IP practice area showcase is part of our Summer Associate Hub live virtual series, where students can learn about what it's actually like to work in big law in different practice areas and prepare for the recruiting process by understanding better what different practice areas actually mean. We have a really nice panel with great attorneys in different areas of IP law, and I'm sure you'll enjoy it. So people use the term IP law, but it actually covers a broad set of practices: patent prosecution or filing, patent litigation, other IP litigation such as trademarks, copyrights, trade secrets, IP licensing or technology transactions, and other areas within intellectual property. These areas of IP all have different skill sets and required expertise. You may love working in one, but maybe not the other, but they also have a lot in common. So this session will help you go a level deeper in thinking about what type of work you might want to do and get some more education about what IP law is. So the agenda is as follows. We'll have a really insightful panel discussion featuring our attorneys from Crowell, Fisher Richardson, Sterne, Kessler, and Fenwick. That will be about 30 to 40 minutes, including Q&A. After the panel discussion, each firm will host a separate Zoom room for those who want to join, ask questions, or listen to hear more about the firm. We're going to send all this information in the chat for folks to join those. In the meantime, throughout the discussion, feel free to use the Q&A to ask questions for the panel generally, and we can tee those up at the end. And before we wrap up the panel discussion, we'll also have some prize raffles for firm swag, the holy firm swag, which is always great, sponsored by each firm. You have to be present to win, so stick around, and we'll be calling your name out. So if you win, so don't go anywhere, and we'll put all the information in the chat for folks to sign up and be entered in those. Great. So before we jump in, quick intro. What is Summer Associate Hub? Summer Associate Hub is a free content and resource hub for law students embarking on the 1L and 2L recruiting process. I'm a former law student and big law associate. We know from our own experience how hard it is as a 1L to understand what it's really like to work at a law firm. Our platform, summerassociatehub.com, has blog posts, podcast episodes, short video tutorials and exercises, interviews with attorneys, and other content to help you learn about practice areas and prepare for the recruiting process. We also host live virtual programs, which you know about because you are watching one right now. And students can easily learn directly from and network with law firm attorneys and recruiting team members on sessions like this. We have a ton of awesome programs scheduled for the spring semester, including an entire series of virtual programs, which we're a part of right now. So definitely, we'll pop the link in the chat. Definitely feel free to sign up for the ones we have coming up if you haven't already. And all of those sessions will have breakout rooms hosted by each firm for students to network and ask questions. We're also planning in-person networking opportunities this summer in New York City, so stay tuned on that as well. Great. So we'll post the RSVP link for all those different sessions in the chat, including our corporate M&A practice showcase next Tuesday after the long weekend. We have a Bay Area location showcase next Wednesday, Chicago week after that, and real estate as well. The best thing to do is to sign up for our newsletter, summerassociatehub.com/newsletter. We'll pop that in the chat. But if you already signed up for this event, don't worry, we've already added you. All right, great. So a lot of info there, but hopefully helpful. Let's jump in with our fantastic panelists. So we're gonna, I guess, take turns to introduce yourself and your practice, and briefly why you chose to do IP. So instead of me introducing everyone, I'll let everyone introduce themselves. So I'll just go in order of my screen. So Marsha from Sterne Kessler, kick us off.
Hi, I'm Marsha Gillentine. I'm from Sterne, Kessler, Goldstein, and Fox. We are an intellectual property boutique law firm located in Washington, D.C. I have been with Sterne Kessler now for almost 22 years. I have a bachelor's in chemistry from Berry College in Rome, Georgia, and a PhD in biological chemistry from University of North Carolina at Chapel Hill, and I got my law degree from George Mason. I went into IP primarily to focus on patents. And my practice right now is about half patent prosecution, which is where I work with clients to procure patents from the United States Patent and Trademark Office, and then work with my colleagues around the world to get patent applications for them in various countries. Work a lot in the biotech and chemical field. And I joined because I love doing science. And I felt that being a bench researcher was just way too limiting. And I always tell everybody and kind of joke around that I have found the perfect place for me because I have learned more science by doing the patent, especially patent prosecution, than I ever did as in the classroom.
Great, amazing. So next, Ray, introduce yourself from Fish and Richardson.
Hey everyone, my name is Ray Crisler. I was a summer associate with Fish and Richardson back in 2014. After I was a summer associate, I clerked for a federal judge out in Las Vegas for the Super Bowl role. And now I am a principal at Fish. I'm based in our Dallas office, but I work remotely from Richmond, Virginia. My practice focuses on pharmaceutical patent litigation. I litigate both small and large molecules, which means that I represent brand name drugs against generic manufacturers on the small molecule side. And I handle patents related to biologics and biosimilars on the large molecule side. I agree with Marsha in that I think that I've learned more science now than I ever did when I was in school. But I didn't start off knowing that I wanted to practice patent litigation. I tried out a few different practices while I was in a summer associate at a mid-sized general practice firm. And I also was a summer associate at Fish. And after having those two experiences, I knew that Fish was the right fit.
That's great. Thanks, Ray. So Joseph, we'll turn it over to you. Introduce yourself and briefly why you chose IP.
Yep. Hi, my name is Joseph Schenck. I'm a partner in the San Francisco office at Fenwick and West, which has sort of offices in a few places. My practice is focused on advising tech companies, I would say like 99% of the time, on corporate transactions from an IP perspective, letting our clients know about sort of IP related issues, sometimes patents. I got into IP because I have a software engineering background and I just thought that fit in nicely. And it has come sort of, I actually agree with what others have said. I've learned more about software as a lawyer than I ever did, writing a bunch of lines of codes in my prior life. And I came to Fenwick 8 years ago, mostly because I had not known that people get paid to do work in the video gaming space. So I get to do a lot of work in that and really happy to do that. Excited to be here.
Awesome. Thanks, Joseph. And last but not least, Mark.
Hi, everybody. I'm Mark Supko. I'm a partner in the Washington, D.C. office of Crowell and Mooring. We're a AmLaw 100 general practice firm with about 120 lawyer IP practice. My practice is devoted almost entirely to IP litigation, mostly patent litigation involving computer or electrical technologies. Do a little bit of mechanical litigation as well. Also do trade secrets litigation, copyright litigation, generally that involves computer software, and a little bit of antitrust litigation as well. I took a fairly traditional, or what at least used to be a fairly traditional route to IP law. I was working as a systems engineer for a General Motors subsidiary developing plant floor robotics programs, and started to feel like I wanted to do something a little more interactive, not just sitting in an office drafting code. And a friend of a friend turned me on to patent law, said this would be a great way to still stay technical, but do something a little more interactive, a little more business focused. So I went and joined one of the old line IP boutiques, worked during the day as an IP lawyer and went to Georgetown at night, and then stayed on with that firm for about 10 or 12 years. And I've been at Crowell for about 22 years. So I guess I'm the old guy. There's, from my perspective, tried a lot of different areas of IP law. Trying patent cases to a jury is the most fun you're ever going to have in a work context. So really enjoyed it and looking forward to talking.
Great, thanks, Mark. So I think one common theme we're seeing is just the ability to, as an IP lawyer, to learn a lot of different things outside of just the law, which is fascinating and great. So Joseph, back to you for a second. So what are the typical matters you would work on in your day-to-day as an IP licensing technology transactions attorney?
Okay, the first thing I'm going to do is take issue with Mark said about patent litigation being the most fun. I get to play video games as part of my job. So, and as a lifelong gamer, I'm like, it's great that I get to do that. I'm just kidding. But so my practice, our group is we usually call it like the major minor because we wear two hats as a tech transactions lawyer, right? The half of my practice is helping advise clients, whether on the buy side or sell side of large, what we call it mergers and acquisitions or financings, advising the client on sort of IP related issues. If there are patent litigations, like, what's going on with them, have all the employees assign the IP properly. So that kind of stuff, like, right. And that's usually very large teams doing all kinds of things in that arena. And then the other hat I wear is what I would call like sort of licensing hat. We're advising clients on various tech transactions or I guess technology transactions, where we're advising clients on how they license their IP to prospective customers, or how you as a customer are going to use a third party software and the like. Right. So I would say right now, I would say it's about split half and half. And I think most technology transaction lawyers are probably doing some mix of that.
Nice. Thanks, Joseph. So go back to you, Mark. What are the typical matters you'd work on in your day-to-day as an IP litigator and working with high-tech companies?
Well, if we focus just on the patent litigations that I work on, I'll typically have 2, 3, 4 cases at various stages going on at any given time. And depending on the stage of the case, you may be very busy, maybe advising a client about a complaint we're getting ready to file, complaint that was just filed against a client, alleging patent infringement. But those cases tend to last 2, 3, or more years. So we may spend a year of a case just working on what we call fact discovery, trying to get information from the other side. They're trying to get information from us. Some of that is written, some of that's document production. Then we go into the more fun stuff, I think, when we're taking depositions or defending depositions of our clients. Then the cases kind of progress through that stage to expert discovery. Patent cases are very expert intensive. So if you're on the plaintiff side, we've got a technical expert who's going to be explaining why our patent is infringed. We'll have a damages expert explaining what we think we're owed for the infringement. The other side will have their own experts. Once you get through expert discovery, maybe we're dealing with summary judgment motions where one side or the other is trying to win the case on the papers before you get into trial. And then if you survive all that, if you're lucky and the case doesn't settle, lucky for the lawyers, clients like when cases settle, typically, then you start getting ready for trial, and eventually you get into trial. So depending on where any particular case is at that time, you're dealing with those various issues. Typically, I'm supervising younger attorneys. We've got typically a kind of a pyramid of folks who are working on these cases, depending on the size of the case. More senior you get, the more opportunities you get for stand-up, either in court or taking depositions. But it's a progression. And then once you get to trial, if you're lucky enough to get into trial, that's just another beast in and of itself. It's difficult for somebody who hasn't gone through it to appreciate the volume of work that's involved when you're at trial, but it's also as rewarding an opportunity as you'll get. It's, like I said before, it's a lot of fun to go through, but it really gets you to appreciate kind of the culmination of those couple of years of work that you put in building your case, and actually see what you've built and try to present the case to a jury. So lots of variety in what it is that we can do.
Great. So Ray, on to you. You also work as an IP litigator. Take us through what typical matters you'd work on in day-to-day as an IP litigator within the life sciences space.
I'll try to build on what Mark talked about and focus on it from more pharmaceutical perspective, which is what I practice. I work on matters both before and during litigation. Before litigation, we often call that diligence. What we're doing is we're trying to make sure our clients' patent portfolios are really the best they can be. We'll work with prosecutors like Marsha just to make sure that everything looks good with the portfolio, and there's something else we can do there from a litigation perspective. And we want to make sure that those patents accurately represent what the invention was. We talk with inventors to learn what the invention was, what their story was, how they got to the invention. And at this stage, we're already deciding what we think our trial themes are going to be. We'll look at lab notebooks and other documents that relate to the invention, and we try to figure out early on what the weak points in the case are and prepare for those weak points even before we have a complaint filed. During the litigation, it looks a lot like what Mark mentioned. We work with technical experts that help us understand really the finer parts of the technology, and they can help us hone some of our case theories. I personally really enjoy working with experts because they're usually people who are at the top of their field, often in the academic setting. They have sometimes authored some of the seminal works or treatises on a particular field. And so it can be really exciting to work with those kinds of people. In my work on the small molecule side, I often work with crystalline material. And so I'm often involved with things like X-ray powder diffraction data, which really I didn't know about before I started this job. But I work with that frequently now to help identify crystalline material. As far as the evolution of the case, again, it looks very similar to what Mark mentioned. But a difference with pharmaceutical litigation is that we have sometimes more of a time crunch. We have statutory deadlines that we have to meet with our litigation, or somebody could lose rights, or somebody could just lose a lot of money. One situation that happens sometimes is that a generic company can launch its generic drug products before we get to trial, which can mean either the generic's going to end up losing a lot of money, or our branded client's going to end up losing a lot of money. So we try to complete litigation before that happens.
Thanks for that. Yeah, that's great. So Marsha, take us through your day-to-day as a patent prosecution attorney.
So a patent prosecution attorney, so one thing about IP, it's not just different technologies. It's not licensing. It's not litigation. There's a lot of nuances in IP. And so patent prosecution really becomes a client counseling role where we work with the business units, we work with the inventors to try to come up with those invention stories that Ray was talking about and try to set those up in our patent applications. And we also have to think about worldwide. Some things we can do in the United States that we can't do in Japan. And so you have to have the client's entire business focus in mind when you're writing those patent applications. And one thing I love about patent prosecution is I get to work with the inventors before their invention actually gets publicized. And so I get to see those developing technologies before they hit the market, or they're in the somebody's winning a Nobel Prize, or, science and nature journals. So I get to be a total science geek, which is what I absolutely love about patent prosecution. And the other nice thing is I'm not limited to a certain type of technology. Biotech and chemical practice is very, very broad. So in the same day, I can work on an application to an antibody, a small molecule, or even, some sort of additive for rubber to be used in a tire, or something else for cosmetics. So I don't have a typical day. It changes when I wake up and check my email from the client. It's like, oh, by the way, we might have a partner that's interested in acquiring us. Could you please confirm that our patents actually cover our product? And so I'll also, sometimes it's kind of the reverse of what Ray's talking about, which is a client will come to me with the product and say, can you take a look and see what patents are out there? How can I design around those patents so that I don't get sued by either Ray or Mark? And or if I do, I get out of it really, really fast. And another aspect of it, which I also consider prosecution, but it's also sort of pseudo litigation, is when they come to me and say, okay, fine, we can't design around this patent application. Should this patent have even been granted from the patent office? And so then I'll do what's called an invalidity analysis, which is to go through and make sure it meets all the requirements of the statute. And sometimes, the answer is, yeah, the patent office did a great job. let's think about maybe doing a different product. Or, but other times the answer is no, the patent office shouldn't have issued the patent. And then, we'll get sued by Ray, Ray or Mark. And then we leave that to the client's litigators. But it's great because there's so many different aspects to patent prosecution, and it is different from one day to the next month. So while most of my time is spent writing things to the US Patent Office to explain, oh, examiner, this is a fantastic invention and here's all the reasons why, and nobody came up with it, but it's not always that way. And sometimes it is sitting there at the board office, which is also a lot of fun, is to, the board of the company and explaining how their patents match their business desires. So I'm at the very early stages. I'm helping the companies build their patent portfolios to either be acquired by a company or eventually to assert it against somebody else. So much earlier upstream.
Yeah, that's great. So yeah, thank you for that overview. So I'm going to pass it back to, I guess we'll stay with you, Marsha, and Mark, feel free to chime in here as well. So, and before I get to this, actually, just a reminder to everyone who's on here, we have a Word document that we posted in the Zoom chat. That document has all of the Zoom breakout links, so definitely open that document and save it so that you can join the breakout rooms after the session. That has also links to join the different firms' mailing lists, which we can also post in the chat. It has a link to join our raffle and to sign up for upcoming events. So check out that Word document in the chat. We're also going to, I'm just going to resend it right now. It didn't work. Okay. So anyway, let's move on to the next question. So Marsha and Mark, so for a student who's interested in IP, but not sure between IP litigation or IP prosecution, what are the main differences between each one? And I know you talked a little bit about what do you enjoy about each, but I guess if any differences that you think are particularly helpful to identify, would love to hear about that.
Mark, if you're okay, I'll jump in first. I've done litigation. I've actually gone to the courtroom. I've never argued. I'll leave that to the experts that are on this panel. One thing about patent prosecution is you can typically plan your deadlines ahead of time. You know exactly what's due when. You can plan your vacations around that. I've had where a judge has dropped you're going to have a hearing on Monday and it's Tuesday, and you're expected to drop everything and show up. The other thing about patent prosecution, again, is for me, the variety of science that I get to see and the variety of technologies. I can work on 100 different cases in a single year. My experience with litigation was not the same, but I'm happy to hear from Ray and Mark if they disagree with that.
Yeah, I think Marsha's hit the main differences there. The traditional difference is predictability of your schedule. Patent prosecutors are no less busy than patent litigators, but as a litigator, you don't know when an opponent's going to file a motion that you're going to have to respond to on a very short turnaround. And again, trial is kind of a different animal. Trial is pretty all-consuming, and there's a little bit of a lifestyle choice to be made there. It's certainly possible to be a trial lawyer and have a family. I had 4 kids, and I think there was maybe one event that I missed throughout my 4 kids growing up. I had to miss one high school graduation because it was in the middle of trial. But you learn to deal with these things. You may be working very long hours, but you go home, you spend some time with your kids, and then you go back to work at night if you need to. So you deal with it. It can be challenging, but it's also very rewarding.
That's great. And I think a good contrast. So Ray, you work within IP litigation, but in a more specific sub area of life sciences. So I guess tell us more about why you chose that area once you knew you wanted to go into IP.
Yeah, so I think the easy answer to that question is that it fit my background. My background is in biology, so moving into life sciences really just made sense. But the full story is really that I didn't start with life sciences. I've handled a number of different technologies throughout my career, from mobile devices to butane blending into gasoline to trampolines. And I've enjoyed working on all of that. But life sciences is what gets me really excited to go to work. The pharmaceuticals that I've worked on and continue to work on, they're life-saving and life-changing drugs. And I find getting to work on that kind of material and technology to be really personally rewarding. One of the cases that I worked on, I got to know an inventor over the course of 4 years. Mark mentioned that these cases go on for a long time, and that's correct. You get to know these people and get very close to them over the course of the litigation. And in this case, this inventor had invented a new molecule that could safely treat HIV without patients needing to take a whole cocktail of pills. And it was really gratifying to get to see over the course of that 4 years how invested he was in his invention and how willing he was to carve time out of his schedule to help us protect it. As we got to trial, he was so excited to get on the stand and tell his story of how he got to his invention. It was a really interesting story. Those are really the parts of the job that I enjoy the most.
That's great. So Joseph, you work in a different area of licensing and transactions, sometimes related to patent, sometimes not. So I have a couple questions for you. One, I guess, take us through briefly kind of the other areas of IP that we haven't covered yet, which is we talked about patents a little bit, but what are the types of IP you work on and how do those differ from patents? I guess namely trademarks, copyrights, and trade secrets. And then I'll have a follow-up question for you once you tackle that.
Actually, I wanted to add on something to what the others
Sure.
have said already about the distinction between sort of litigation and transactional, right? I did not know about the distinction so much when I was a first-year law student, right? And I often hear first years talk about, why they're interested in one or the other. It sometimes revolves around like, I'm not a confrontational person, so that's why I lean towards transactional, right? And I also actually started as a litigator, and I found litigation to be less adversarial, except maybe at the very end when you're at trial and everyone cooperates but in transactional work, it gets very adversarial oftentimes, right? So I want to dispel that notion that as a transactional lawyer, I admit that we can be very adversarial people, right? Going back to the question, in terms of the types of IP, I will make it easier to understand from my perspective, like I do a lot of work in the video gaming space, right? So as it relates to copyright, it's going to be sort of the code in the copyright. It's going to be in the characters, right? So we advise clients on all kinds of perils and ownership issues that revolve around copyrights and how you use it and protect rights around that. Trademarks, obviously things like Google and character names and so forth. So we advise clients on how to license and protect those things. Trade secret, actually, Mark sort of, talked about sort of trade secret misappropriation, that he does litigation on that. So we advise on sort of how to protect those. And oftentimes, actually, and the patent people are be better, maybe even Marsha, like how trade secrets evolve into patents. So there's questions about how you protect it until it evolves into a full-blown patent at some point. Yeah.
Great, and I'm gonna pop in some extra color in the chat in the meantime. But so Joseph, so you work with areas that are outside of the typical patent prosecution and IP litigation. So, what can a student do to set themselves up for a career in transactional IP or technology transactions? And do you need any particular advanced degrees or qualifications or anything like that?
Yeah. So I will start with technology transactions is sort of like a subset of corporate, right? So one thing is it's important to understand what it is we do versus corporate largely. I, again, did not know what tech transactions was when I was a 1L. I just knew there was corporate and there was litigation. I didn't even know there was patent prosecution. I just assumed everyone just litigated about patents, right? So some of this is more about like learning what each role is. And I think in all cases, it's more about aptitude than like having I work with people who are in life sciences. They don't have biology degrees and they're just as good. I have a software engineering background, but I work with people who deal with software that are excellent, right? So I think it helps to have these backgrounds, but at the end of the day, it's about aptitude and interest. And I would say, and if you want a career in this, take all the IP classes you can. Even if I took a patent class, and even though my patent practice is like 0.0002%, it's always helpful to know what the difference between a patent is and a copyright is, right? So I would say, like, show an interest in IP and concentrate on aptitude, and don't worry about so much about, like, at least from a tech transactions perspective, what your previous degrees were in.
So Albert,
Great.
I'd like
Yeah.
to follow up on Joseph's
Please.
point. Is there's a big misconception that you have to have an advanced degree to be able to be a patent prosecutor. And I will certainly say it helps. Having the focus on the science and the in-depth scientific research certainly helps to know about the technology, but it is definitely not required. It's the aptitude and the ability to learn that really matters, and even in a patent prosecution. Now, one thing that is different than litigation and corporate work is, for a patent prosecutor, they have to be able to sit for the patent bar, which does require certain scientific courses. And so, but that's available on the PTO's website. They do not require a science degree. They just require a certain number of courses to be able to sit for the patent bar. And I've had colleagues who have been litigators and have gone back and taken those courses on their own from local universities and have sat for the patent bar much later in their career, just so that they could say they did it. So certainly keep that in mind, that it's not required, but it is helpful to have the advanced degree.
And Marsha, I'm glad you chimed in with that, because I think that is a common misconception, especially when it comes to the patent bar requiring an advanced degree. So that's great. That's great information, and hopefully helpful for all of our students who are watching right now. Great. So we have a few more minutes before we jump out to the breakout rooms. So this is a fun thing that we'd like to end with before we take a few questions from the Q&A. So now is your chance to plug the firm. In 30 seconds or less, and I mean that 30 seconds or less is a hard rule. We'll start playing the Grammy music. So now's your chance to plug the firm. We'll take turns. Why should someone choose your firm in 30 seconds or less? We're also going to raffle off some fun swag kind of as we go. So if you haven't signed up already to join the swag raffle, definitely do so. And I'm going to include the link once again in the chat, and definitely open up that Word document with the Zoom breakout rooms. I'll send that once again to make sure that you can access those and meet all the attorneys afterwards, and access all the other links. All right, so 30 seconds or less. Why should somebody choose your firm? I guess Ray, we'll start with you. Why should a student choose Fish?
Fish is great. It offers top tier training opportunities and early responsibility. Junior associates get the opportunity to develop and lead strategies with more senior attorneys supervising them. And the firm emphasizes next-gen stand-up opportunities. So early on, people are getting the opportunity to argue motions and claim construction, and in some cases, even appeals.
Great. So we're gonna do the raffle off some Fish swag while we're talking about Fish. So let's see. Gonna do this really quick.
Are the panelists eligible?
I don't know. Unfortunately, I don't think so. Unless I would. If I'm not eligible, nobody's eligible. I'm still waiting for swag. I haven't gotten one thing yet. All right, so Joshua Massey, if you're here, you are the winner of the Fish swag. Let us know in the Q&A if you're here, and we'll get that set up for you. All right, so Joseph, you're next. 30 seconds or less. Why Fenwick?
I would say, if you like working with big banks and doing that kind of private equity stuff, we're not the place for you. If you like working on interesting transactions with technology companies, we are the place for you. And if I had not known that you could get paid to do work in the video gaming space, so I will plug that. And I will just say, like, my claim to fame is I helped the New York Times buy Wordle, and I'm still living that to this day, where people are upset about it from both sides. But if you like, you never know when you're going to make an impact. I say my firm brings joy to people. Ray makes differences in people's lives, right? So for what she does, I focus on joy.
Fantastic. All right, and I forgot to mention the Fish prize is a very cool Fish Sherpa blanket. So congrats to Joshua. Let us know if you're here. All right, so Fenwick, we're going to be raffling off a Fenwick swag bag. It's very fun. It's a mystery bag. So what we know about it is that it's Fenwick branded. All right, so JC Bissell, if you're here, please let us know you are the winner of the Fenwick swag bag. All right, Mark, on to you. 30 seconds or less. Why should a student choose Crowell?
Crowell and Mooring is a great place to start a career in IP law. We give all of the benefits of an IP boutique within the context of a large, multifaceted general practice firm. We don't take ourselves too seriously, which is kind of fun, and probably got rubber duck swag that we're giving away. There's a long story that goes behind that, kind of dates back to our founder, Crowell, who really instilled in the law firm, and it goes through the firm's culture to this day, valuing diversity, respect for people, and community service just as much as we value great line service and the bottom.
Great. Thanks, Mark. All right, so we have a double prize for today's winner, a Crowell umbrella and a Swell water bottle, which is always very useful. So Nia, Carol Parker, if you're with us, please let us know, and we'll get that set up for you, Nia. All right, and then last but not least, Marsha, 30 seconds or less. Why should a student choose Sterne Kessler?
Sterne Kessler, we always call ourselves techies. We enjoy the science, and certainly with the law as well. We also have a lot of training, a lot of mentorship, but the nice thing about Sterne Kessler is flexibility. You're flexible to choose your career path. You're also flexible on work-life balance. We have flexible hour programs, and I certainly have taken advantage of the flex hour programs and have dropped my billable hours so that I could have more of a work-life balance. So that's, to me, what made Sterne Kessler special, is the flexibility.
Great, fantastic. So Sterne Kessler sponsored Sterne Kessler gift pack, which includes a Visa gift card, which is always great. So Seth Bodek, if you're here, please let us know in the Q&A, and we'll set you up with the Sterne Kessler prize. All right, so let's take one question from the chat, and I think I enjoyed hearing from everybody, especially like I mentioned as a former IP associate, and I think I'm exhibit A to the example that you don't need an advanced degree or a science background to become an IP attorney. I worked in IP licensing just like Joseph and did not have any science background, and I just chose IP because I was curious and wanted to learn more about companies' technologies and get involved in that. And I think that's hopefully that came through in today's session. So one question: if somebody who doesn't have a background in technology or science, are there any particular documents, resources that you recommend somebody becoming familiar with, for example, to become familiar with different areas of IP or the process for registering a patent? Hopefully there's some resources out there. I guess I'll tee it up for one person to chime in on this one before we go to the breakout rooms.
I'm happy to jump in, just to make one point that I'm not sure came across before. Yep. Even if you want to be a patent litigator, you don't need to have a technical degree. I don't have a technical degree. I did work in software development before I went to law school, but I don't have a science degree. And there's some benefit to that, because you're going to have to understand an invention and then explain it to somebody else, maybe 8 people sitting on a jury who most likely don't have a technical degree, or a judge that doesn't have a technical degree. So being able to internalize that and communicate it, and not having that background yourself helps you do that. So don't feel like if you don't have a technical degree, you can't be a patent litigator.
I'll just add, please take a general IP class where you learn about the differences of IP. Those differences in IP are going to serve you regardless of what any of the careers that we're on here, I think.
Yeah, I'll jump onto that. Actually, I think the most rewarding class that I took from a practice standpoint was an IP transactions class, because even though that is not my practice, that is something that I still have to deal with all the time with settlement agreements. I interact with our transactional folks to make sure that everything ends up looking correct, but I still have to have that baseline knowledge. So I just echo those same points of taking as many IP classes in law school while you can.
Great. Well, thanks everybody for this wonderful discussion. Hopefully very helpful for students about learning about what it's like to be an IP attorney as they consider different practices in their career. So hopefully all the students can join our breakout rooms. I posted this in the chat. Save the Word document for all the different breakout room links. And please join us to engage with the attorneys and the recruiting team members of the different firms. One thing to note, we definitely encourage everybody to visit more than one breakout room, engage with more than one firm, get the different perspectives from the different attorneys and the recruiting team members of the different firms, especially as everybody's taking time out of their evening to be with us. So thanks everybody for joining. One more plug for Summer Associate Hub for our future events. Please visit summerassociatehub.com/events to sign up for our future sessions coming up next week and the weeks to follow. And thanks again to our wonderful panelists for a really nice and helpful discussion about working in IP law.
Thanks meeting you all.